The Companies Act 1956, Section 5, meaning of officer who is in default. Officer who is in default. Many among us are aware or familiar with this expression, officer who is in default. Many sections of the Companies Act 1956 carry penal provisions wherever the company fails or is in default in complying with the provisions of the Act. Such provision will carry or will bring us an expression, officer who is in default. This is very popular and very interesting expression. We need to refresh ourselves. For our reference, may we go to section 22. Clause subsection 2 of section 22 says, if a company makes a default, underline, if a company makes default in complying with any direction given under clause B of subsection 1 of section 22, the company shall be punishable. So if a company makes default in complying with any direction, or if a company makes default in complying with any provision of the Act, such a company shall be punishable. For example, so apart from the company, every officer who is in default shall also be punishable. So many provisions of many sections say on similar lines. Again, clause subsection 2 of section 22, let us have a look. If a company makes default in complying with any direction given under clause B of subsection 1, the company shall be punishable, and also every officer who is in default shall be punishable with fine. So let us go to another section, section 39. I request you to focus your attention on the expression officer who is in default. Again, I request you to focus your attention on the expression officer who is in default. We are going to focus today's discussion or today's refresh on the expression officer who is in default. As I was telling you earlier, let us go to section 39. You have another instance. Subsection 2 of section 39 also refers the expression officer who is in default. Subsection 2 of section 39 says, if a company makes a default, if a company makes a default in complying with the requirements of this section 39, the company and every officer of the company who is in default shall be punishable. Again, if a company makes a default in complying with the requirements of this section, the company shall be punishable, and also every officer of the company who is in default shall also be punishable. May we have another reference? Let us go to section 44. Here, subsection 3 of section 44 says, if default is made in complying with subsection 1 or subsection 2 of section 44, the company shall be punishable. and also every officer of the company who is in default shall be punishable. Similar many sections are having penal provisions. Wherever the company makes default, it shall be punishable, and also every officer who is in default shall also be punishable. So why I refer three sections which carry this penal provision and where we may identify the expression officer who is in default, just to familiarize ourselves and understand it a bit more. I have referred it. Let us go to our subject section, section 5 of the Companies Act 1956. Section 5, meaning of officer who is in default. Officer who is in default. As I was requesting you, today we are going to focus our attention on the expression officer who is in default, and we may refresh ourselves in understanding the expression officer who is in default. Let us go what section 5 says in explaining the expression officer who is in default. For the purpose of any provision in this act which enacts that an officer of the company who is in default shall be liable to any punishment, shall be liable to any penalty, whether by way of imprisonment or fine or otherwise. That penalty or that punishment may be by way of imprisonment, by way of penalty, fine or otherwise. This is how it is going to explain us. For the purpose of any provision in this act which enacts that an officer of the company who is in default, an officer of the company who is in default shall be liable to any punishment or penalty. That punishment or penalty may be by way of imprisonment, fine or otherwise. Further, section 5 goes to explain the expression officer who is in default means what? Means all the following officers of the company. In the expression officer who is in default, again in the expression officer who is in default means, as far as section 5 goes, officers of the company. Which officers of the company are refer in the expression officer who is in default? Which officer? Section 5 brings us 6 clauses: A, B, C, D, E, F. Apart from 6 clauses, there is another clause, G clause. So 6 clauses brings us explanation about officers of the company. 7th clause is little bit different. 7th clause refers about clause E and F. Let us go. The expression officer who is in the default means all the following officers of the company. All the following officers of the company, namely the managing director or managing directors, officers of the company, namely the whole-time director or whole-time directors. Repeat. For the purpose of any provision in this act, for the purpose of any provision in this act which enacts that an officer of the company who is in default shall be liable to any punishment or penalty, That punishment or penalty may be by way of imprisonment, may be by way of fine or otherwise. Now let us go to understand the expression officer who is in default. Here in this expression officer who is in default, you underline the word officer. So which officer of the company is referred here? Section 5 says following officers of the company are identified. Who are these officers? Officer of the company, namely the managing director or directors. Clause A of section 5. Officer of the company, namely the managing director or managing directors. Clause B. Officer of the company, namely the whole-time director or whole-time directors. Clause C. Officer of the company, namely the manager. Yes, what you are listening is correct. I am saying the manager. The act also is saying the manager. Singular word. It is not plural. The managers. Underline. It got lot of sense. Why the word the manager singular is used, not plural? You may understand after some time. The expression officers of the company, namely the manager, clause C. Clause D. Officer of the company, namely the secretary. Till now, we refer 4 officers. Number 1, managing director or managing directors. Clause B, whole-time director or whole-time directors. Clause C, the manager. Clause D, the secretary. All are designated. You are aware of it. Let us go to clause E and F, where we may not find any designated person. Clause E and clause F says about any person. Underline. Any person not designated till now. See what clause E of section 5 says when it is going to explain about the officers of the company. Clause E. Any person in accordance with whose directions or instructions the board of directors of the company is accustomed to act. See, any person in accordance with whose directions or instructions the board of directors of the company is accustomed to act is also recognized as an officer in section 5. Let us go to section 6, that is clause F. Any person charged by the board with the responsibility of complying with that provision or with any specific provision or complying with any certain provisions. To understand it, a person may be charged by the board with the responsibility of complying with any specific provision, or a person may be charged by the board with the responsibility of complying with any specific provisions or certain provisions. This clause F carries a proviso. It says, provided that the person so charged has given his consent in this behalf to the board. So such a person who is charged by the board with the responsibility of complying with any provision or with such specific provision, he needs to give his consent in this behalf to the board. Let us go to clause G. Where the company doesn't have any of the officers specified who where it doesn't have the managing director or managing directors, where it doesn't have whole-time director or whole-time directors, where it doesn't have the manager. In such a case, any director or directors who may be specified by the board in this behalf, or if it not takes place, where no director is so specified, all the directors are identified as officer as far as section 5 goes. Again, where any company doesn't have managing director, where any company doesn't have whole-time director or whole-time directors, where any company doesn't have the manager, in such a case, any director or directors who may be specified by the board in this behalf. So any director or directors may be specified by the board in this behalf as an officer. If it has not happened in such a case, all the directors are identified as officers of the company as far as section 5 goes. Clause G of section 5 carries a proviso provided that where the board exercises any power under clause F or clause G, it shall within 30 days of the exercise of such powers file with the registrar a written in the prescribed form. May we understand, may we refresh where this proviso is relevant. Let us go to clause F. Clause F. Officer means any person charged by the board with the responsibility of complying with that provision or with any specific provision or with certain provisions, provided that the person so charged has given his consent in the behalf to the board. In this situation, the company needs to file with the registrar a written in the prescribed form within the period of 30 days of such exercise of powers, because the board of directors is exercising its power by charging a person with the responsibility of complying with the specific provisions, and the person so charged has given his consent in this behalf to the board. In such a case, the board needs to file with the registrar a written in the prescribed form within 30 days of the exercise of such powers. Similarly, clause G refer where any company doesn't have any of the officers specified in clause A to C. It means where any company doesn't have any officers like managing director, where any company doesn't have whole-time director, where any company doesn't have the manager. In such a case, the board of directors take or exercise a power like any director or directors who may be specified by the board in this behalf. So the board of directors may specify any director, or the board of directors may specify some directors as officers. Assume that the board of directors has not specified any director or any directors. All the directors are identified as officers. This is what clause G says. So in such a situation also, the board of directors need to file with the registrar a written in the prescribed form within 30 days of the exercise of such powers. Here, we are able to refresh very familiar expression, officer who is in default. It is not due to all of us how important this expression, officer who is in default. Let us repeat it again. Let us have refresh Section 5 of the Companies Act 1956. Section 5 is coming forward who are officers of the company. Clause A says managing director is an officer of the company. Company, the officer of the company. Similarly, the whole-time director or whole-time directors, the manager, the secretary. First, managing director. Clause B, whole-time director. Clause C, the manager. Clause D, the secretary. All these identified or designated officers are mentioned. In addition to these, if any such designated officer is not available, any person in accordance with whose directions or instructions the board of directors of the company is accustomed to act. That is what clause E says. So officers of the company, namely the managing director or managing directors, officers of the company, namely the whole-time director or whole-time directors, officers of the company, namely the manager, officers of the company, the secretary. So all the following officers are called officers of the company. For the purpose of any provision in this act which enacts that an officer of the company who is in default shall be liable to any punishment, shall be liable to any penalty, that punishment or penalty may be by way of imprisonment, fine, or otherwise. The expression officer who is in default means all the following officers of the company. So the word officer I request you to underline and remember and focus your attention. The expression officer who is in default means all the following officers of the company. Who are the officers of the company? Let us re-understand. Clause A, managing director or managing directors. Clause B, the whole-time director or whole-time directors. Clause C, the manager. Clause D, the secretary. Clause E, officers of the company, namely any person in accordance with whose directions, in accordance with whose instructions the board of directors of the company is accustomed to act. Officers of the company, namely clause F, any person charged by the board with the responsibility of complying with that provision, provided that the person so charged has given his consent in this behalf to the board, and where the board exercises such power under clause F, it shall within 30 days of the exercise of such powers file with the registrar a return in the prescribed form. Let us go to clause G. Officer of the company, namely when any company doesn't have any of the officers like the managing director, where it doesn't have any whole-time director or whole-time directors, where any company doesn't have the manager, it shall, in such a case, the board of directors may specify any director or directors as officers. Assume that the board has not specified any director or directors as officers. All directors of the company are recognized or deemed as officers as far as clause G of section 5 of the Companies Act 1956 goes. Where any company doesn't have any of the officers like the managing director, the whole-time director, or the manager or secretary, the board may specify any director or directors as officers. If it has not specified any director or directors as officers, all the directors are recognized or deemed as officers. In such a case, the board shall within 30 days of such power file with the registrar a return in the prescribed form. This is how we are going to further understand about section 5, meaning of officer who is in default. We are able to refresh again very interesting expression, officer who is in default. You may be understanding, you may be having a doubt why I am repeatedly saying very interesting expression, officer who is in default. It is not only an interesting and very important also. This expression is very important to me. This expression is very interesting to me. Is it not interesting to you all? I expect it is interesting because the Ministry of Corporate Affairs is very much worried about registrar of companies. Why registrar of companies are not applying their minds in understanding or in interpreting section 5, meaning of officer who is in default of the Companies Act 1956. I am not saying that registrar of companies are not applying their minds in understanding section 5, meaning of officer who is in default. The Ministry of Corporate Affairs is saying that registrar of companies need to apply their minds in understanding section 5. It has issued, underline, it has issued many circulars explaining section 5, meaning of officer who is in default. Before going to understand what Ministry of Corporate Affairs said about registrar of companies, let us have the meanings of the words or the terms which we come across in section 5. We come across 4 words. In clause A, managing director. In clause B, whole-time director. Clause C, the manager. Clause D, the secretary. Meanwhile, may we also have definition of director. Clause 13 of section 2 says about director. Director includes any person occupying the position of director by whatever name called. Very interesting definition. Clause 13 of section 2. Director includes any person occupying the position of director by whatever name called. Why it is saying whatever name called? Because director sometimes get designated as managing director. Some directors sometimes get designated as whole-time director. Some directors may remain just as directors. That's why it is saying by whatever name called. Repeat clause 13 of section 2. Director includes any person occupying the position of director by whatever name called. You may be aware, director shall hold nominal value of the qualification says which are required to be held by a director. You are aware of this. Let us go to clause 24 of section 2, how it defines the word manager. This manager word we come across in section 5 at clause C. Let us refresh the definition of manager. Who is manager? As far as clause 24 of section 2 goes, manager means an individual who, subject to the superintendent's, subject to the control and subject to the direction of the board of directors, has the management of the whole affairs of a company and includes a director or any other person occupying the position of a manager by whatever name called and whether under a contract of service or not. So, a director may also be designated as a manager. Manager will have the management of the whole of the affairs of a company, or the manager may have substantially the whole of the management of the affairs of the company, subject to the superintendents of the board of directors. This point we need to underline. The manager has the management of the whole affairs of the company, but subject to the superintendents of the board of directors. Manager has the management of the whole of the affairs of the company, subject to the control and direction of the board of directors. This we need to remember always. Manager shall have the management of the whole of the affairs. How? Subject to the superintendents, subject to the control, and subject to the direction of the board of directors. This is how the manager shall have the management of the whole of the affairs of the company. You may get some semblance when we go to the term managing director. Managing director means a director who, by virtue of an agreement with the company, managing director means a director who, by virtue of a resolution passed by the company in general meeting, or managing director means a director who, by virtue of a resolution passed by its board of directors, or managing director means a director who, by virtue of its memorandum or articles of association, is entrusted with substantial powers of management which would not otherwise be exercisable by him, and includes a director occupying the position of a managing director by whatever name called. See, the managing director means a director who is entrusted with substantial powers of management. Underline. Managing director is entrusted with substantial powers of management. Is anyone else entrusted with substantial powers of management in the company? None. Only the managing director shall be entrusted with substantial powers of management, which would not otherwise be exercisable by him. And also, clause 26 of section 2 says, it includes a director occupying the position of a managing director by whatever name called. You are all aware, we come across just a couple of seconds back the expression substantial powers of management, very important term. It carries different meaning and most powerful expression, powerful meaning. Only the managing director will have substantial powers of management. Here, clause 26 carries a proviso that says that the power to do administrative acts of a routine nature, when so authorized by the board, such as the power to affix the common seal of the company to any document, is an administrative act. The power to draw or endorse any check on the account of the company in any bank is an administrative act. The power to draw and endorse any negotiable instrument is an administrative act of routine nature. The power to sign any certificate of share is an administrative act of a routine nature. The power to direct registration of transfer of any share is also an administrative act of a routine nature. All these acts, all these administrative acts of a routine nature shall not be deemed to be included within the expression substantial powers of management. Provided further that a managing director of a company shall exercise his powers subject to the superintendent's, subject to the control, subject to the direction of its board of directors. You are right. This expression you have come across in the definition of manager also. Manager also functions subject to the superintendents of the board of directors. Managing directors also functions subject to the superintendents of its board of directors. This we need to underline. Both officers, manager and managing directors, function subject to the superintendent's control and direction of the board of directors. There was another expression, secretary. Secretary means a company secretary. Secretary means a company secretary within the meaning of clause C of subsection 1 of section 2 of the Company Secretaries Act 1980, and includes any other individual possessing the prescribed qualifications and appointed to perform the duties which may be performed by a secretary under this act, and other ministerial and administrative duties. So here we were able to understand, we were able to refresh officers, and who are recognized as officers like the managing director, the whole-time director, the secretary. Now the word, very important word, till now we were referring the word officer. What does clause 30 of section 2 says? Let us understand. Clause 30 of section 2 says officer includes any director, any manager. Officer includes any secretary. Repeat. Clause 30 of section 2 says officer includes any director, officer includes any manager, officer includes any the secretary. Again, clause 30 of section 2 says officer includes any director, officer includes the manager, officer includes the secretary, or any person in accordance with whose directions or instructions the board of directors or any one of the directors is or accustomed to act. Let us go to clause 31 of section 2, officer who is in default. Here it just says in relation to any provision referred to in section 5 has a meaning specified in that section. In that section means section 5. Section 5 we have come across already. Here one expression we need to focus a bit attention. Expression is person in accordance with whose directions or instructions directors are accustomed to act. Let us understand. Let us refresh ourselves. What does it mean? Person in accordance with whose directions? Person in accordance with whose instructions directors are accustomed to act. Section 7 of the Companies Act 1956 says, except where this act expressly provides otherwise, except where this act expressly provides otherwise, a person shall not be deemed to be within the meaning of any provisions of this act. A person shall not be deemed to be a person in accordance with whose directions or instructions the board of directors of a company is accustomed to act, by reason only that the board acts on advice by him in a professional capacity. Underline, in a professional capacity. Advice given by him in a professional capacity. Officers in default. So the bankers, auditors, professionals, advisors may come to your mind while understanding person who has given advice in a professional capacity. Let us repeat a bit revision about section 5, meaning of officer who is in default. We were referring Ministry of Corporate Affairs in the mid of our discussion, while we were refreshing ourselves officer who is in default. I was referring you how important the expression officer who is in default, how the Ministry of Corporate Affairs was serious about the registrar of companies regarding the lapses rolling on. May we turn our attention the Ministry of Corporate Affairs by its Master Circular number 1 2011 dated July 29th 2011. Repeat, Government of India, Ministry of Corporate Affairs by its Master Circular number 1 2011 dated July 29th 2011. It says, the question of treating a person as an officer in default by ROC, question of treating a person as an officer in default by registrar of companies when prosecutions are launched against a company and its directors for violation under Companies Act 1956 has come up for examination time and again. The question of treating a person as an officer in default by registrar of companies has come up for examination time and again. Repeat, the question of treating a person as an officer in default by registrar of companies when prosecutions are launched against a company and its directors for violations under Companies Act 1956 has come up for examination time and again. The department has issued various circulars in this regard so far. The Ministry of Corporate Affairs has issued various circulars explaining what? Explaining officers in default, which is very well available from the provisions of section 5. Even then, the Ministry of Corporate Affairs is bound to issue various circulars in this regard. The registrar of companies are able to understand, are able to interpret Section 5 of the Companies Act 1956, most of the time perfectly well. But unfortunately, there are many instances where the interpretation of the Companies Act 1956 Section 5 went wrong. That is the reason Ministry of Corporate Affairs is very much worried. How much it is worried, let us understand. It has come to the notice of the department that in spite of various rulings available on the question of officers in default who can be held liable for violations of a particular provision under the Companies Act 1956, the registrar of companies are arraigning all the directors of the company for the violations without differentiating between officer in default and others. Underline. The registrar of companies are arraigning all the directors of the company for the various violations. How? Without differentiating in between officer in default and or others. May we repeat it? It has come to the notice of the department that in spite of various rulings available on the question of officers in default, underline, on the question of officers in default who can be held liable for violations of a particular provision under the Companies Act 1956. Even then, the registrar of companies are arraigning all the directors of the company for the violations without differentiating between the officer in default or others. So where is this understanding going wrong with the registrar of companies? Why the registrar of companies are arraigning all the directors of the company for the violations? Why are they not able to differentiate the meaning between officer in default and others? This is what the Ministry of Corporate Affairs is very much worried. Let us go to paragraph 7 of the Master Circular. Here it says, there should be proper application of mind on the part of the registrar of companies. Are you getting shocked? Otherwise, if it has come to your notice earlier, it might have shocked you also. See what the Ministry of Corporate Affairs is saying. It is saying in paragraph 7 of the Master Circular, there should be proper application of mind. There should be proper application of mind on the part of the registrar of companies. Underline. On the part of the registrar of companies in deciding whether a person to be implicated is an officer in default. See how serious it is. The Ministry of Corporate Affairs is also went further and say there should be proper application of mind on the part of the registrar of companies in deciding whether a person to be implicated is an officer in default. At the end of paragraph 7 it says, wherever the registrar of companies has doubt, see, when the registrar of companies is not in a position to understand properly Section 5 of the Companies Act 1956, it is advising the registrar of companies wherever the registrar of companies has a doubt as to whether director or officer can be held liable after applying the above parameters. Master Circular has provided some parameters and explained. You may ask me a question. Are these parameters mentioned in master circular are totally new? No, not at all. The parameters are not new. The parameters mentioned in master circular are not at all new. The parameters are explaining the very provisions of Section 5 of the Companies Act 1956. Even then, registrar of companies are not able to understand it in a right direction, in a right perspective. It is not we are saying, it is not I am saying. The Ministry of Corporate Affairs is clear. It is clearly understanding the lapses taking place from the side of registrar of companies. Wherever the registrar of companies has doubt as to whether the director or officer can be held liable after applying the above parameters, they should refer to the regional director who shall guide the registrar of companies in this matter. Let us hope the regional directors may be able to understand, the provisions of Section 5 of the Companies Act 1956 and see it will mean what the Companies Act 1956 mean. The master circular consolidates all circulars, all previous circulars. This is what master circular from the Ministry of Corporate Affairs coming forward with saddened mood explaining the, may we call it, failure in understanding Section 5 of the Companies Act 1956 on the part of the registrar of companies. We may not, because Section 5 itself may appear as confusing. No, not at all. It is not so. We all need to focus our attention in understanding the provisions of Section 5 of the Companies Act 1956. Again, in the end, may we revisit Section 5, meaning of officer who is in default. For the purpose of any provision in this Act which enacts that an officer of the company who is in default shall be liable to any punishment or penalty. May I request you all, let us refresh it again. See the lapses taking place on behalf of registrar of companies and how the Ministry of Corporate Affairs is serious, and it has told that it has issued many circulars explaining the meaning of officer who is in default. Repeat Section 5, meaning of officer who is in default. For the purpose of any provision in this Act which enacts that an officer of the company who is in default, an officer of the company who is in default shall be liable to any punishment, shall be liable to any penalty. That punishment or penalty may be by way of imprisonment, fine, or otherwise. The expression officer who is in default means all the following officers of the company. All the following officers of the company. Namely, Clause A, the managing director or managing directors. Clause B, the whole-time director or whole-time directors. Clause C, the manager. Clause D, the secretary. Clause E, any person in accordance with whose directions or instructions the board of directors of the company is accustomed to act. Clause F, any person charged by the board with the responsibility of complying with their provision, provided that the person so charged has given his consent in this behalf to the board. Clause G, where any company doesn't have any of the officers specified, the managing director, the whole-time director, or the manager, Any director or directors who may be specified by the board in this behalf, or where no director is so specified, all the directors are identified as officer of the company as far as the meaning of officer who is in default section 5 of the Companies Act 1956 goes. Clause G carries a proviso where the board exercises any power under clause F or clause G. It shall within 30 days of the exercise of such powers file with the registrar a return in the prescribed form. We are very happy we are able to refresh section 5 meaning of officer who is in default. Let us hope we are all able to understand it in right direction, in right perspective. Thank you.